The word itself conjures dread. You're picturing months of lost rent, legal fees, and the headache of removing someone from your property. But what if I told you that the typical California eviction, from first notice to sheriff lockout, takes 60 to 90 days and can easily cost you $5,000 to $15,000 out of pocket? Most landlords just accept this as the cost of doing business. They shouldn't. You're losing money you don't have to. The vast majority of evictions are preventable or, at the very least, resolvable before you ever step foot in a courtroom. If you're not actively preventing them, you're bleeding cash. Before you even think about filing an unlawful detainer lawsuit, you must serve proper notice. This isn't a suggestion, it's the law. California has strict requirements, and messing this up is the fastest way to get your case dismissed, forcing you to start over, losing weeks and hundreds of dollars. The most common notices are the 3-day notice to pay rent or quit, and the 3-day notice to perform covenants or quit. For periodic tenancies, a 30, 60, or even 90-day notice might be required depending on how long the tenant has lived there and your local rent control ordinances. For example, under AB 1482, if a tenant has resided in the property for 12 months or more, you generally need to provide a 60-day notice to terminate a periodic tenancy without cause. And even then, cause is often required. Now here's where it gets interesting. Many landlords serve these notices incorrectly. They hand-deliver when they should mail, or they omit crucial language. A legally valid notice must state the exact amount of rent due, the names of all tenants, your property address, and a clear demand for payment or possession within the specified time frame. If you miss a single detail, a judge will throw out your case. Don't rely on generic online templates. Consult a local attorney or use a compliance service. The cost of a professionally drafted notice is around $100 to $200. Compare that to losing a month of rent, easily $2,000 to $4,000 in California, if your notice is defective. Once your notice period expires and the tenant hasn't complied, you file an unlawful detainer lawsuit with the Superior Court. This is the official start of the eviction process. You'll pay a filing fee, typically around $240 to $450, and then you'll need to properly serve the summons and complaint to the tenant. This means a registered process server, not you, must personally deliver these documents. Expect to pay another $75 to $150 for process serving. But wait, there's a catch. Tenants have 5 days to respond to the lawsuit once served. If they don't respond, you can file a request for default, and the court may issue a default judgment in your favor, speeding up the process significantly. This is your best-case scenario. However, many tenants, especially those with legal aid, will respond. They might file an answer, a demur, or even a motion to quash service. Each of these responses adds weeks to the timeline. For instance, if a tenant files an answer, a trial date is typically set within 20 days, but court backlogs can extend this. If you're representing yourself, you're at a severe disadvantage against an attorney who specializes in tenant defense. The attorney fees for an uncontested unlawful detainer can range from $3,000 to $7,000. If it becomes contested, those fees can easily skyrocket to $10,000 to $15,000 or more, plus court costs. If the tenant files an answer, your case will proceed to a court hearing or trial. This is where your preparation, or lack thereof, will be exposed. Judges in California are highly protective of tenants' rights. They will meticulously scrutinize your paperwork. Did you serve the notice correctly? Is the amount of rent demanded accurate? Did you follow all local rent control ordinances regarding just cause and relocation assistance? Judges are looking for any procedural misstep that could justify dismissing your case. You need a clear, documented paper trail, lease agreements, ledgers showing missed payments, copies of all notices with proof of service, and any communication with the tenant. If you claim a breach of lease, you need evidence, photos, repair invoices, witness statements. For example, if you're evicting for non-payment, bring your detailed rent ledger. If the tenant claims they paid and you don't have a clear record, the judge might side with them. This is why meticulous record-keeping isn't just good practice, it's your defense. A judge will not take your word for it. They require evidence. Losing in court means starting over, or worse, the tenant stays and you've incurred thousands in legal fees for nothing. Even after you win your unlawful detainer case, your tenant isn't automatically out. The court will issue a writ of possession, which you then deliver to the county sheriff. This is the final, legally mandated step to regain your property. The sheriff will post a 5-day notice to vacate on the property. If the tenant doesn't leave within those 5 days, the sheriff will return and physically remove them, changing the locks and ensuring the property is vacant. This process itself costs money. Sheriff fees can be $150 to $250. And it adds another week to the timeline. Remember, until the sheriff officially locks out the tenant, they are still legally in possession, and you cannot take any self-help measures like changing locks or removing their belongings. Doing so could open you up to a separate lawsuit. This final step is often the most frustrating, because even after all the legal battles, you're still waiting. A typical eviction timeline from the day you serve the first notice to the day the sheriff locks out is 60 to 90 days. During that time, you are likely receiving no rent. If your rent is $2,500 per month, that's $5,000 to $7,500 in lost income alone, on top of the $5,000 to $15,000 in legal and court fees. The best eviction is the one you never have to file. This starts with rigorous tenant screening. Don't rely on gut feelings or basic credit checks. You need a comprehensive background check that includes credit history, criminal history, eviction history, and thorough income verification. California law allows you to screen for these. A tenant with a prior eviction on their record is a massive red flag. Why would you risk a $15,000 headache to save $50 on a background check? But prevention doesn't stop at screening. Early intervention is critical. If a tenant misses rent, don't wait. Contact them immediately. Understand their situation. Sometimes a payment plan can prevent an eviction. Consider cash for keys, offering a struggling tenant $1,000 to $3,000 to vacate voluntarily. Sign a mutual termination agreement and leave the property in good condition is often far cheaper and faster than a full eviction. That $1,000 incentive could save you $14,000 in legal fees and 3 months of lost rent. Data consistently shows that tenants offered cash for keys vacate faster and leave properties in better condition, reducing turnover costs. Don't be emotional. Be strategic. Your goal is to regain possession of your property with minimal financial damage. Key takeaways. A typical California eviction takes 60 to 90 days from notice to lockout. Attorney fees for a contested case can reach $15,000. Your best defense is a strong offense, thorough screening, and proactive problem solving. And remember, offering cash for keys, often $1,000 to $3,000, is a significantly cheaper and faster alternative to a lengthy, costly legal battle. Don't lose money on preventable problems. Powered by LeaseBase Intelligence.